And arbitration is a very informal process where two contracting parties, in some cases there are two domestic companies, in some cases it is one international company, in which case it becomes international commercial arbitration. They enter into an agreement. An agreement is a more formal contract which they enter into. In that, an arbitration agreement or an arbitration clause, as most of you all know, is a very vital part of the particular document. In often, as far as our practice area is concerned, we often tell clients that clients consider or treat an arbitration agreement as a 4 a.m. or a midnight clause. Less attention is paid to the clause. Parties are only focusing on the commercial aspects. They frequently, most often, consider that disputes as far as their commercial relationship is concerned will never come about. It is only when a dispute arises that the parties tend to get back to their contract to see what the exact nature of their arbitration agreement is, and which can get very critical. Why I say that it gets critical? Because the wording of an arbitration agreement can seldom lead to either confusion, and then that confusion translates itself into delay for the dispute resolution. So the whole intent of arbitration being a quick fix mechanism for dispute goes for a complete toss. To put it more firmly, I would say that an arbitration agreement is the backbone of the entire arbitration process. It's, as a dispute lawyer, my job towards my client, or my responsibility towards my client as far as disputes or prospective disputes is concerned, begins from the stage of drafting an arbitration agreement.